Good morning, everyone. Welcome to Assembly Judiciary. Welcome to everyone here in Carson City, as well as anyone down there in Las Vegas, and of course, watching on our legislative YouTube channel or through Nellis. And with that, Committee Secretary, please take the roll.
Assembly members Cole, Dahlia, Gonzalez, Gray, Hanson, Hardy, LaRue Hatch, Marzola, Moore, Nadeem, Orenlicker, Roth, Urick, Chair Miller.
Here. And please mark Assemblymember Gray present when he arrives. Assemblywoman Moore is now walking in. Please mark Assemblywoman LaRue Hatch present when she arrives. Okay, a few more reminders as we go through. Please just make sure that you turn off your electronics as we're going through today's meeting so as not to disrupt anyone. Also, we'll begin with a work session and then a bill hearings on two bills. Anyone presenting for bills, we ask that you keep your comments to 15 minutes, and anyone testifying or calling in for or making a public comment, please make sure you keep your remarks to 2 minutes. We ask that everyone speaking first state their name and then spell it so we have it correct for the record. I will provide the number right now for those who will be testifying or making public comment through the phone. The phone number is 888-475-4499, and today's meeting ID is 851-834-42537. Also, please keep in mind that you will see members coming and going off of the dais today. We have a few members that will be presenting bills in other committees, so please understand when they're leaving, that's where they're going. And also, of course, members are always looking at their devices as they're communicating and doing research as well. Committee Secretary, please mark Assemblymember Hardy present. And with that, we will begin with our work session.
Thank you, Chair. For the record, Cesar Magarejo, Committee Policy Analyst. And for the record, as nonpartisan staff of the LCB, I can neither support nor oppose any of the measures that come before this committee. Our first bill for work session today is Assembly Bill 473, which makes an appropriation for a forensic DNA testing program and sponsored by this committee. And Chair, there are no amendments.
Thank you. Members, any questions? Not seeing any questions, I will entertain a motion to do pass. I have a motion from Vice Chair Marzola. Do I have a second? I have a second from Assemblymember Gonzalez. Any additional comments about the motion? Not seeing any. All those in favor, please say aye. Aye. Anyone opposed? Nay. Okay, so the nays are Assemblymember Hanson, Assemblymember Gray. Those were the only two nays? Okay, thank you. The motion passes, and I'll assign that floor statement to Assemblymember Orenlicker.
Thank you, Chair.
You're welcome. Next one, please.
Thank you, Chair. For the record, Cesar Magarejo, Committee Policy Analyst. Our next bill is Senate Bill 17, which revises provisions relating to specialty courts, sponsored by the Senate Committee on Judiciary on behalf of the Nevada Supreme Court, and there are no amendments for this measure.
Thank you so much. Members, any questions? Not seeing any. I'll entertain a motion to do pass.
So moved.
I have a motion from Vice Chair Marzola. Do I have a second? A second from Assemblymember Gonzalez. Any additional comments? Not seeing any. All those in favor, please say aye. Aye. Anyone opposed? And the motion passes unanimously. I'll assign that floor statement to Assemblymember Roth. You're welcome. Members, we are going to roll SB 20's work session till Monday, so we are now going to go to SB 26.
For the record, Cesar Magarejo, Committee Policy Analyst. Next bill, Senate Bill 26, revises provisions authorizing certain entities to obtain information relating to the records of criminal history of certain persons responsible for the safety and well-being of children, elderly persons, or persons with disability. And this bill is sponsored by Senate Committee on Judiciary on behalf of the Records, Communication, and Compliance Division of the Department of Public Safety. And there are no amendments for this measure.
Members, any questions? Not seeing any. I will entertain a motion to do pass. I have a motion from Vice Chair Marzola. Do I have a second? I have a second from Assemblymember Gray. Any additional comments? Not seeing any. All those in favor, please say aye. Aye. Anyone opposed? Okay, and the motion passes unanimously. I will assign that floor statement to Assemblymember Cole. You're welcome. Next one.
Thank you, Chair. For the record, Cesar Muguerel, Committee Policy Analyst. The next bill is Senate Bill 30, which revises provisions relating to prisoners and is sponsored by a Senate Committee on Judiciary on behalf of State Board of Parole Commissioners, and there are no amendments for this measure.
Thank you. Members, any questions? Not seeing any. I'll entertain a motion to do pass. I have a motion from Vice Chair Marzola. Do I have a second? I have a second from Assemblymember Nadeem. Any additional comments on the motion? Okay, all those in favor? Aye. Anyone opposed? Okay, and the motion passes unanimously, and I'll assign that floor statement to Assemblymember Nadeem. You're welcome. Last bill, please.
Thank you, Chair. For the record, Cesar Muguerel, Committee Policy Analyst. Our next bill is Senate Bill 66, which revises provisions governing certain post-conviction petitions for a writ of habeas corpus, and was sponsored by a Senate Committee on Judiciary on behalf of the Attorney General, and there are no amendments for this measure.
Thank you. Members, any questions? Not seeing any, I'll entertain a motion to do pass. I have a motion from Vice Chair Marzola. Do I have a second? I have a lot of seconds. All right, Assemblymember Gonzalez, I'll take, or did I hear a Urick down there? I heard a Hanson. Okay, I heard a lot. So Assemblymember Hanson, I'll give you the second then, okay? And I will give you that floor statement as well. You're welcome. Oh, did we vote? Okay, all those in favor? I'm still giving her the floor statement. All those in favor? Aye. Anyone opposed? Okay, and the motion passes unanimously. All right, and that was the last one for today. Okay, thank you, members. Next item on our agenda today will be our bill hearings. We will start with Senate Bill 140, which revises provisions governing certain programs of treatment established by the juvenile court. And so, Senator, I'll give you a few moments to get in and get settled. Do you have someone presenting on Zoom as well? No? Okay, that must be the next hearing. And so whenever you're ready to begin, your bill hearing's open, so just please proceed.
Good morning, Chair Miller, members of the Assembly Judiciary Committee. For the record, my name is James Orenshaw. I represent State Senate District 21 down in Southern Nevada. And with me co-presenting, I have Judge Sonny Bailey from the 8th Judicial District Court. I first met Judge Bailey many years ago. As many of you know, in my normal life, I'm a deputy public defender in juvenile court. And practicing in juvenile court for many years, when I first started in delinquency court, there would be clients, there would be children who would be accused of a delinquent act, who were very often, we suspected they might be on the autism spectrum. And there really was not a lot of programming trying to help those children. Judge Bailey started a special court down in the 8th Judicial District Court called Day Court. It's an acronym DAAY, Detention Alternatives for Autistic Youth. What her court does, just to talk a little bit about it, and I'll let her go into more detail, is it tries to help children who are on the spectrum or may be suspected to be on the spectrum and maybe have never gotten a diagnosis, never gotten any treatment, connect with that treatment and be diverted out of the judicial system and hopefully, never end up in juvenile delinquency court again. The court has a very, very, very high success rate with the children that she's been able to help. At court hearings, she has tons of service providers there to try to help the child and their family, their guardian, not just for the next 6 months or for the next 12 months, but in many cases for the rest of their lives to try to help with therapy, with treatment, with housing, with job training. So it's really, in my mind, just one of our best community courts and an incredible therapeutic court for children who very often before maybe parents had wondered, is there something here that my child needs some help, but they never got connected with someone to get a diagnosis, with someone to get therapy. Senate Bill 140 seeks to expand the work of this therapeutic court to children with other neurobehavioral disorders. And with that, Chair Miller, I'd like to turn it over to Judge Bailey, and then I'm happy to answer any questions about the bill.
Good morning. Please excuse me, this is a little bit different than my normal job, as Senator Orenshaw stated.
Would you like to switch seats? Would you feel more comfortable then?
No, thank you. And I'm Judge Sonny Bailey, and it's Soonhee, last name Bailey, Bailey. First of all, I'd like to thank everyone for last session for voting and supporting SB 411 that created the diversionary court and actually created it. And thanks to all of you, we became the first state in the nation to actually have a diversionary court and recognize a diversionary court. And we're actually the only state that recognizes a diversionary court for youth on the spectrum. And after that, the rest of the country actually took notice. We had calls from all over the country wanting to know how we did this. We had calls from lawyers, we had calls from parents, we had calls from other legislators wanting to know how we did this and how they could do it as well. And so we spoke all over the country, and we still answer questions to this day, and we're extremely proud of this model that we created. And this model, Day Court, we recently just graduated last month, our 105th graduate, and we're maintaining a success rate of 90%. So we're very proud of our program and the success rate. This remarkable achievement underscores the sustainability and effectiveness of our approach. Day Court exemplifies a system. We hold our youth accountable while providing the support and resources necessary for their growth and their rehabilitation. We focus on the appropriate individualized care, which our specialized program allows us to do, support and community involvement, and we ensure that each participant is given the tools to succeed, reducing their recidivism and fostering positive outcomes, which not only keeps them out of the juvenile justice system, but our hope is to keep them out of the adult system as well. In your last legislative session as well, which can't be ignored, you also expanded the definition of developmental disabilities under NRS 435-007 subsection 5, which included fetal alcohol spectrum disorder, so FASD. And FASD and neonatal abstinence syndrome, NAS, they're neurodevelopmental disabilities that result from prenatal exposure to alcohol, opioids, and other substances. And FASD currently affects approximately 1 in 1,000 infants, while NAS is diagnosed every 24 minutes currently. Thousands of children in our state are impacted by conditions that hinder their cognitive, emotional, social, and behavioral development. The CDC currently estimates that as many as 1 in 20 school-age children have FASD. This legislative change ensures that these children can receive recognition and support that they deserve, aligning with our commitment to inclusivity and comprehensive care. Without proper supports, children with FASD and NAS, they face significant challenges. These children often struggle with issues such as impulsivity, poor social skills, inability to solve problems, and difficulty learning from past experiences. One of the most unsettling issues, and one of the things that we need to notice, is that over 30% of these children usually end up in our child welfare system. Sadly, the impacts can be even more far-reaching, and many of these children end up in the juvenile justice system, struggling with disrupted school experiences and involvement with the law and challenges with adapting to adulthood. In fact, these children that have issues with disruptive school experiences, they experience things such as suspension, expulsion, and a dropout rate. The rate starts at 43%, often up to 70% when they reach adulthood. This is compounded by the fact that 60% of individuals age 12 and over with FASD experience trouble with the law. The most common crimes that we see are crimes against person, followed by property damage, and this puts family members, our teachers, students, first responders, and our community in general at risk. A recent study found that youth in the juvenile justice system are 40 times more likely to have FASD than the general population, and tragically, 95% of those are undiagnosed. And a similar study in Canada prison system found that FASD is disproportionately represented in the prison population, with up to 31% of prisoners affected, far higher than the general population rates. The recommended treatment for FASD includes applied behavioral analysis, which is ABA. It's the same treatment that we use in our autism court and for autism spectrum disorder. And since 2021, NRS 422-2719 has required Medicaid to cover ABA services for FASD, which is why it's so natural for us to look to expand our day court to include this population. However, obtaining a diagnosis for FASD is incredibly time-consuming and difficult, which is why 95% of our youth go undiagnosed. Currently, the wait list in Clark County for FASD testing is over 18 months long, with only the Ackerman Center available. The current cost is approximately, it's over $7,500 to get that test. Ackerman Center only does 4 testings a month because Medicaid only covers approximately about $750 of that testing. They rely upon grants from Grant to Gift to cover the rest. And during this time, many of the youth that are already in our delinquency system, they're committing more crimes, and they face commitment or placements in residential treatment centers. If they're also in our child welfare system, it's almost impossible to find placements, much less appropriate other placements or adoptive resources for these youth. This is why SB 140, the bill that we're considering today, is so critical. By adding FASD and NAS to NRS 62B 700, we're taking the logical next step forward. Our community providers and our partners have long been requesting this expansion, and this expansion will allow for the same interventions that have already proven successful in our day court program. The current model will reduce the waiting time for evaluations by over a year, and will ensure that children born with these conditions will receive the support that they need to thrive. Just as we set precedent with the passage of SB 411 last session, Nevada has the opportunity to lead once again, and we request your support for SB 411 to provide critical support for our children, for FASD and NAS, and prevent future involvement with the criminal justice system. Thank you very much.
Thank you very much, Chair Miller, and I'm happy to answer any questions about the bill.
Thank you so much. Before we get to questions, would you mind giving us a brief summary of what the day program actually looks like? Maybe the length, the types of programming, how many youth you have on average. I think you said there was, 105 that graduated? Even using the term graduating is different. And also what types of offenses and crimes you take. Is it youth with violent, nonviolent, either or both? Could you just give us a brief summary of that program?
This is Judge Bailey for the record. Yes, we actually have different programs. We will have youth that may qualify for diversion, such as battery, domestic violence, and we may have things such as usually those battery on a teacher. We also have things such as we may have some juvenile sex offense crimes as well. Those crimes are not diverted. Those crimes, we will be a condition of probation on those crimes. And then for those that complete our program, which can be anywhere from 6 months to over a year if it's a term of probation, they would then obtain, if they do not already have a diagnosis, we would get them a neuropsychological in order to get them diagnosed. Once they are diagnosed, they would then get community resources such as Autism Treatment Assistance Program, Desert Regional Center. We would then help them through that process by streamlining that process so there's not so long of a wait. We then obtain services or help the family obtain services through ABA with the different providers. And then we look at social programs such as we have sports social, inclusion, fusion, things like that. We then have legal aid available for those who qualify to verify that the IEP is appropriate for each of our youths, because some of them may have inappropriate IEPs that don't address the behavioral issues. And then we have the wraparound services. Do they need PSR, BST? Then we evaluate the behaviors and we target specific behaviors. If it's violent behaviors due to denied access, we look at reducing those targeted behaviors. They then check in with us anywhere from every month to every 2 months to make sure that the targeted behaviors are decreasing. Once we have the targeted behaviors decreasing and we have ABA in place, once we have success over approximately about 3 months, then we consider them graduated graduated from our program. If it's a low-level misdemeanor on diversion, they would then earn their dismissal. If they're still on probation, then we would graduate them from ours and refer them back to their original judge, and then that portion of their probation is complete. As far as the new program, it would run very similar. Hopefully that answers your question.
The last question, what are the ages?
And this is Judge Bailey again. Anyone who enters into the juvenile justice system, so it would be 10 and up.
Okay, thank you so much. What is up? Where's the ceiling?
This is Judge Bailey. Juvenile jurisdiction ends at age 18.
Okay, thank you so much. With that, we will start with member questions. We will begin with Assemblymember Ornlicker.
Thank you, Chair, and thank you for bringing this bill. My question is about you talked about the children who had exposure to alcohol prenatally, and it's a well-defined syndrome. I'm interested in also other controlled substances, because I remember during the war on drugs and cocaine babies, there was all this concern about the effects of controlled substances on babies, and then it turns out that their neurodevelopmental delays were attributable more to their family's poverty, nutrition issues, other things were more important than the exposure to the drug. So I wonder if we're perpetuating an unfortunate myth about the causes of the neurobehavioral problems with children whose parents were exposed to controlled substances, that the focus should be more on these other causes of their delays rather than the controlled substances.
This is Judge Bailey. To answer your question, we actually rely on a team of specialists to make the diagnosis, which looks at the cognitive, intellectual, and other issues. So it does tie back to the actual drug use. So as far as the poverty or the others, I don't know of those studies, but we rely on our experts, so we would not be looking at the other issues that you have. This is specifically related to the substance exposure. So these are the experts that we have. Yes.
So let me phrase it a different way. If you had a child who had comparable neurobehavioral issues, but you couldn't connect it to exposure to controlled substances, does that mean they wouldn't be eligible even if they have the same level of neurobehavioral problems?
This is Judge Bailey. We would not see those children because they would not be flagged for our program.
Chair, with your permission, James Ornshaw, Senate 21. Certainly, I'm not a medical expert or in terms of some of the studies that you bring up, but some of the, just anecdotally, some of the neuropsych evaluations I've seen for children I've represented in juvenile court, these are very extensive evaluations that can sometimes be 40, 50 pages, where the doctor has not only, done a whole battery of tests for the child, but also looked into history, tried to get records of parents and medical records, records at birth and during pregnancy. So, those are very extensive, the neuropsych evaluations that I've looked at. And of course, that's just my anecdotal experience. I'm not an expert as to some of the studies you bring up.
And this is Judge Bailey again. The records that we do have are going to be extensive from birth to the time that they test. So it's going to have the entire history. So a lot of our children will be able to track the history, and what you're looking at, they will be able to track all the way up as far as the development of the child. So some of the issues that you're discussing wouldn't be factored in. They'd be able to look at everything. So I'm afraid that I couldn't answer all your questions because I'm not the expert, but I think some of the factors that you're looking at wouldn't be factors in the issues that we're looking at. Obviously, it's looking at the entire history, but we have an extensive history that they look at. We're talking about 500, 600, 700 pages of medical history that our experts are looking at, and it's a panel of 4 that are actually doing the evaluations.
So with that, So trying to take it from in the legal process. So a youth is arrested for a crime. And again, one of the challenges is that there's not a lot of diagnosis. And so that was one of my questions too, is now I believe I'm hearing different. So one of my questions was, how can a youth qualify for this diversion court? Is it because they already have an IEP or they already have a diagnosis of this from a medical doctor? This would, of course, be an obvious situation, right? But now I believe I hear you saying that students that don't have a diagnosis or an IEP, that you would have them diagnosed, but how is that determined? How do you determine which youth get the opportunity to be to be evaluated and go to diversion court, and which ones do not?
This is Judge Bailey. This works similar to what the system we already have in place for day court. We have probation officers, clinicians, and defense attorneys who are very apt at meeting their clients, meeting with them and evaluating them, and then talking with them, and then looking at the history, speaking with them, and then noticing if there's an issue. Is there a cognitive delay? Is there something? And then speaking with them, starting to get the history, starting to talk with them. And then if they note that there may be an issue, we have whether or not there's already a diagnosis or a suspected issue. And then once there's a suspected issue, then they flag it, and then they go before the court and say, we think there's a suspected issue of FASD. And then at that point, then there's a record gathering time period. If they can gather the records, then at that point they make the referral so that we can get them in for testing. So it's a similar process that we already have for day court. We can then do the testing as we assist with gathering the records. So then we can get the testing done so that they don't have to wait for the 18-month period. So we can work on that to get appropriate diagnosis.
And Chair, with your permission, James Ornshall said at 21, putting my defense attorney hat on again. As a public defense attorney in the office I work in, and I believe in a lot of, public defense offices that represent juveniles in delinquency court, I'm very fortunate to have a social worker as part of our team. And very often, if I speak with a child, parents, and I suspect that a child may be on the spectrum, may have been diagnosed, maybe hasn't been diagnosed, but exhibits some traits, I will ask my social worker to connect with the child and their family and try to obtain medical records, try to go through that, because that might be something that would help the child qualify for the day court program. And I believe a lot of private attorneys, while they may not have a social worker, will also try their best to try to get those records as well when they represent children in delinquency court.
Okay, so then I have another question. You're saying that you're already doing this, but that the measure we passed last session were for those that were on the autism spectrum, and this bill is requesting to do this. So is this already happening? And if so, what is the need for the bill?
This is Judge Bailey. We already try to do this for those with suspected FASD. However, we don't have a process that would allow them to have a specialized court. When we add this to a specialized court and we actually have a recognized special court, it allows the court itself to then request funding through AOC, to request grants. It allows our community partners to request grants. So it just opens up more opportunities for people to request grants and other opportunities to help fund these programs.
Okay, thank you. And one last question. So how often do you, and it works both ways, do you miss a youth who would have been diagnosed with one of these conditions, or that you suspect and then you find out the contrary? There's nothing, and I say this as a person who works in the schools, and people are always trying to label, and we have that balance of justice in the school setting as well, as trying to teach kids to be accountable and responsible and good citizens to other people, while understanding certain things may contribute to certain things, but still we're trying to prepare you for the real world. And so often what happens is there are parents that just know that there's some other reason that things are happening, and then we go through the whole battery of everything, and there's nothing clinical or medical or anything happening. So I'm just wondering, how many times do you have youth come in when you're like, oh, there's actually no condition here?
This is Judge Bailey. Unfortunately, as far as FASD, too often in the juvenile justice system, they've either reached age 18 or a probationary term has ended before we've even had an opportunity to test. So I couldn't give you an accurate number, unfortunately. I can't give you a number. That's why we're looking into this program.
Yeah, and maybe not even an exact number, but maybe just a roundabout. But because you're saying that you've been doing this testing, so I'm just, or trying to provide them to get an evaluation.
And this is Judge Bailey. I can tell you that we just tested 3 youth, and all 3 were on the or were FASD.
Okay.
So
Okay, which leads me to one last question that I meant to ask earlier. In the current day program, is there a parent component or requirement?
this is Judge Bailey, and yes, we absolutely love parent training, and it's part of our requirement because behaviors don't occur in a vacuum, and our favorite component is the parent training. ATAP actually offers a supplemental parent training, and part of our expectation through the FASD as well is that same component of the learning the behaviors and how to deal with the behaviors. Because if we don't do that, obviously these things, you can't expect the school to handle them. You can't expect to handle them any other way. The parents need to adjust their behaviors as well on how they react in order to reduce them. So that is a requirement, yes.
Thank you. With that, I don't see any additional questions, so I'll go ahead and open it up for testimony. Starting here in Carson City, anyone that would like to testify in support of Senate Bill 140?
Good morning, Chair Miller, Vice Chair Marzola, and members of the Assembly Judiciary Committee. Paloma Guerrero, Paloma Guerrero, on behalf of the Clark County Public Defender's Office. We support this bill because we know that therapeutic programs work. 90% success rate is an incredible success rate. That means that those kids are less likely to recidivate. It means safer communities. It means that we as a state identified a problem, and instead of discarding those kids and their parents, we decided to invest in them and give them resources so that child can be successful. Any investment we can make into therapeutic programs now will save our state money in the long run and is smart on crime legislation that we can all support. Thank you.
Chair, members of the committee, Jonathan Norman, NORMAN, Nevada Coalition of Legal Service Providers. In Clark County, we have our education advocacy program, which is embedded in our Children's Attorneys Project representing kids in foster care. That team's been embedded in day court since its inception. And I think the power of day court is not just getting that assessment. So if a kiddo, to Assemblymember Orentlicker's question, if a kiddo doesn't, it's just poverty or they're not eligible, they are still connected to legal aid, and we are on that case still making sure that the IEP is followed as long as the parent's engaging. The power of day court, in addition to getting that assessment, is Judge Bailey. So there's status checks where the judge says, parent, are you still working with legal aid to make sure the IEP is right? Parent, are you getting this kid to where they need to go? The power of the judge holding the parent and all the stakeholders accountable makes a huge difference in outcomes versus those kids maybe with an FASD diagnosis. Then we're working directly with the parent without that court oversight and accountability. I think that tracking that Judge Bailey does is really part of what makes this so successful and powerful. So we're still with those kids who it's just poverty, but we don't have, or if it's FASD currently, it's just we don't have the judge having status checks to make sure everyone is doing what they said they were going to do, including the parents and all the providers. So we are in support. Thank you.
Tanya Brown, TONJA, BROWN, Advocates for the Inmates and the Innocent. We support SB 140. This kind of intervention would be instrumental in preventing these individuals from spending a lifetime of an ongoing revolving door of incarceration. Thank you.
Good morning, Chair, members of the committee. My name is John McCormick, John MCCORMICK, Assistant Court Administrator of the Supreme Court AOC, and obviously the Supreme Court supports the expansion of specialty courts. Thank you.
Good morning, Chair Miller and members of the Assembly Judiciary Committee. My name is Jeff Rogan, JEFFROGAN, and on behalf of the Clark County Department of Juvenile Justice Services, we support this bill for all the reasons said by my predecessors. Thank you.
Thank you. Is there anyone else here in Carson City? Not seeing anyone, we'll go to Las Vegas for those in support, please.
Good morning, Chair Miller and members of the Assembly Judiciary. This is Bridget Duffy, BRIGID, DUFFY, Assistant District Attorney for Clark County Juvenile Division. The Clark County DA's office is in support of SB 140. My team staffs the current day court and is getting ready to start staffing the neurodiversion court. So we appreciate Senator Orenshaw and Judge Bailey for bringing this bill forth.
Good morning, Madam Chair, members of the committee. Eric Lovas for the record, ERIKLOVAAS. I'm president of Lovas Center here in Las Vegas. We have a Lovas Center in Spain, as well as a foundation, Eric Lovas Foundation in Spain. I've been at this autism treatment for over 30 years, and I just want to put a plug that we get children with autism, but we don't treat autism. We treat the behaviors associated with autism. And the same could be said with FASD children. Insurance is mandated to pay for both of them because the treatment is effective. I'm here on behalf of my father. He was the gentleman who designed the treatment that's used around the world today, but also want to put a plug in for my mom. She was a former LA County Sheriff who worked the psych ward at Men's Central Jail. And so this is not juvenile, this is adults 18 and older. And I would go visit her and we would walk the halls back when someone like myself was able to go in the back door and see persons with developmental disabilities who were incarcerated and see the conditions that they were forced to live in, the smells, the sounds. And my mom was an amazing behaviorist. She would, at the time, use cigarettes when it was legal to smoke in jail, to make sure that people would keep their clothes on and go to the hallway, go to chow hall, showered. So on her behalf, I'm here and supporting this bill fully. And I just want a special thank you to Honorable Judge Bailey and Senator Krasner and Orenshaw for sponsoring this bill, and thank you for your time.
Thank you so much. Not seeing anyone else in Las Vegas right now broadcasting. Will you open the lines, please?
If you would like to testify in support of Senate Bill 140, please press *9 now to take your place in the queue. Again, if you would like to testify in support of Senate Bill 140, please press *9 now.
Good morning, Chair Miller and members of the Assembly Judiciary Committee. My name is Carissa Pierce, and I'm representing Children's Advocacy Alliance. Children with neurodevelopmental disorders, including those associated with prenatal exposure to alcohol or controlled substances, face significantly poorer outcomes than their peers. These youth are at higher risk of recidivism, school failure, and long-term system involvement due to challenges with impulse control, executive functioning, and emotional regulation. Yet many of these children are not receiving appropriate intervention that they need. And without proper treatment, these children are far more likely to cycle through the system rather than receive the care and services that could help them thrive. By expanding access to specialized treatment programs, SB 140 ensures that courts recognize the unique needs of these youth and connects them with appropriate evidence-based interventions rather than punitive measures. We are in strong support of SB 140 and appreciate your consideration and commitment to Nevada's children.
Thank you. Carissa, could you please spell your name for the record?
Yes. CARISSAPEARCE. Sorry about that. Thank you.
That's okay. Thank you so much. Next caller.
Good morning, Chair Miller, members of the committee. My name is John Abel, representing the LVPPA. We are proud to support Judge Bailey's bill last session. We're proud to support her bill this session. This is a great way to stop that school to prison pipeline. So for that reason, we support this bill. Thank you.
Next caller.
Good morning, Madam Chair and members of the committee. Stephen Cohen for the record. Stephen with a V. Cohen is in the now former Assemblywoman. Thank you, lady.
Thank you so much, Mr. Cohen. Next caller.
Chair, there are no other callers wishing to testify in support at this time.
Okay, then I will open it up for opposition testimony, beginning here in Carson City. Not seeing anyone here in Carson or Las Vegas. Broadcasting, will you open the lines?
If you would like to testify in opposition to Senate Bill 140, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify in opposition at this time.
Thank you. Then I will go ahead and open it up for neutral testimony, beginning here in Carson City. Not seeing anyone here in Carson or Las Vegas. Broadcasting, please open the lines.
If you would like to testify in neutral for Senate Bill 140, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify neutral at this time.
Thank you so much. Then I will close testimony and welcome the senator and judge back up for any final remarks.
Good morning again, Chair Miller, members of the Assembly Judiciary Committee, James Orenshaw, Senate 21. Thank you for hearing Senate Bill 140. I think we're very blessed down in Southern Nevada in the 8th Judicial District Court because the day court program that Judge Bailey has started from the ground up really has helped a lot of children, I think, to avoid being frequent flyers in the delinquency system, and I believe to avoid ending up in the adult system. I hope that the committee will consider this expansion to children who've been exposed to alcohol and other substances. With your permission, Chair Miller, I'd like to give Judge Bailey just a few minutes to close as well. Thank you.
This is Judge Bailey again. I want to thank you again for the passage of SB 411 that has changed so many lives. I thank you again for your consideration and hope that you will pass this and help us to continue to change lives. And I thank you again for making a difference and letting the rest of the nation see what Nevada can do and how innovative we can be. Thank you.
Thank you so much. And even though you didn't invite us to come visit the court, I will not take that personally or...
And this is Judge Bailey. You're welcome anytime.
Okay, thank you so much. With that, I will go ahead and close the hearing on Senate Bill 298. I'm sorry, I will close the hearing on Senate Bill 140, and I will open the hearing on Senate Bill 298. Senate Bill 298 revises provisions relating to peace officers. So I'll give you all a few moments, and I think you had a third person on Zoom presenting. He popped in. Yeah, he should be on. Okay, so here we go. So once you're all settled and ready, Senator, please proceed.
Thank you, Madam Chair, members of the committee. I think this is my first and I think only bill I have in Judiciary, so it's good to see you all. Senate Bill 298 is making one slight change in the Peace Officers Bill of Rights. And I know we have our two co-presenters here, so I'm going to hand it off to them, head back up to Commerce and Labor in the Senate side, if that's okay. And I have complete confidence that these two gentlemen can answer all of your questions.
No problem. Good to see you, Senator. Thank you.
Thank you. Good morning, Chair Miller, members of the Assembly Judiciary Committee. My name is Harrison Porter, Harrison Porter. I'm the Vice Chairman of the Las Vegas Police Managers and Supervisors Association. We represent the sergeants, lieutenants, and captains of the Las Vegas Metropolitan Police Department. On Zoom is my counterpart and chairman, Troyce Crumey. SB 298 proposes to make changes to NRS 289, the Police Officers Bill of Rights, by further defining punitive action to include the denial of an increase in either seniority or compensation, which is necessary. I'd like to share an example for why this change is necessary. We had a member who was denied a standard step increase without due process and without any finding of fault. LVMPD denied his increase because he was under an administrative internal investigation. Once the investigation was completed, they then demoted the member. In effect, the member was disciplined for 3 times for the same act. He had his loss of pay, withholding of his step increase during the investigation, his loss of rank, and that resulted in additional loss of pay during his demotion. We believe this is wrong and excessive. The taking of any part of a person's salary is major discipline because of the compounding nature of one's salary and the reliance people have on their income. This change to NRS 289 protects all peace officers from having pay increases denied without due process or losing seniority without due process. Putting this into law will not prevent departments from holding police officers accountable. That is exactly what the internal affairs process is for. Misconduct is alleged, an investigation is completed, and upon the results of the allegation, discipline may be administered. We have these increases built into our contract. As an association, we even negotiated with LVMPD to allow all increases for the captain rank only be based on merit and performance at LVMPD's request. However, sergeants and lieutenants were not included in these negotiations. Police officers do not have this in their contract, and yet they have suffered from the same issues that we have addressed here today. These are contractually negotiated rights the department has taken away from our members. We want to protect contractual rights for all law enforcement as well as due process. And with that, I'll take any questions.
So before we get to member questions, I think that if you could explain the differences, because as a community, we do want to ensure that police officers are also held accountable. And so I know that there are some very severe cases, some in the media right now, but I don't believe, so if you could just yes or no, we're not talking about those severe criminal grand jury possible, we're not talking about these cases with this bill, is that correct?
Harrison Porter for the record. Chair, thank you for that question. No, this does not protect anybody who is on leave without pay for any criminal investigations. This is strictly for people who are under administrative investigation that are due a step increase to not have it withheld. But no, this does not protect anybody in a criminal investigation.
Okay, so we're speaking work-related, that we would see in any other job, no matter what your profession is, there's certain professional standards. So is that what you mean by administrative? We're talking just general professional work-related issues or concerns?
Harrison Porter for the record. Yes, that's correct.
Okay, would you mind giving us some examples?
Harrison Porter for the record. It could range from anything from contact with the public and being disrespectful. It could be insubordination, violating a policy such as not properly taking care of a prisoner's belongings.
Okay, thank you. So with that, we'll begin with member questions, beginning with Assemblymember Cole.
Thank you, Chair, and thank you for the presentation. I think my question is kind of following along on those same lines. Coming from the private sector, anytime somebody is, not living up to the standards, the thought of giving them a merit increase automatically just wouldn't happen. So it doesn't seem like it's punitive in nature to me. So I guess my question is, can you tell me how many officers, how often this has happened, and on what basis that those were denied?
Harrison Porter for the record. Chair, can I go direct?
Yes, please.
So I don't have exact numbers for you right now. I've been with Metro for over 16 years, and this has been a recent occurrence within the last year and a half, 2 years. I know we've had a member suffer from it, and having talking to the PPA, the officers union, they've had a few members suffer from it as well. But I also want to just emphasize, this isn't a merit increase. This isn't a performance-based increase. This is a contractually negotiated increase. So it has nothing to do with performance. This just has to do with your tenure on the department.
Sure.
Do you think you'd be able to provide exact numbers to the committee? Thank you.
Harrison Porter for the record. I can, try to get those for you.
Next question is from Assemblymember Roth.
Thank you, Chair, and thank you so much for the presentation. Just a point of clarification, this is simply kind of holding everything in place until a decision is made about what the discipline should actually be, correct?
Harrison Porter for the record. Thank you for the question. They're withholding it during the investigation, but what it's actually doing is penalizing somebody. Having talked to John Abel from the PPA, they had a member who went under investigation, had his his step increase withheld, and when the investigation was done, he was given it, but there was no back pay associated with it. It was just he received it, but he lost out on salary for that time.
Please.
Just to clarify, just for a clean record, so what I'm saying is that this is about due process and allowing for where something has been alleged against an individual, we keep their pay in the status quo until the point in time when a full investigation has been made and then a determination on what the appropriate penalty should be. So it's not a get out of jail free card. They can still get penalized. They just keep everything in place until their due process has been borne out.
Harrison Porter for the record. Sorry for the miscommunication. Yes, that is correct.
And that would also lead me to want to ask, because let's be real, we know work is work, right? And people often, there's ways that people can be penalized for certain actions that may not be discussed or explained, especially if like someone's going for a promotion, right? But again, we're talking here, which are automatic according to negotiated agreements, step increases, not merit, just step increases. And so I wonder, was this happening before without notifying the officer? Is this what really this is about? Where people, or is it just to eliminate the actual possibility of denying the step increase? Or is it to make sure that the possibility is communicated?
Harrison Porter for the record. I'm sorry, could you just rephrase that?
Sure. So was this being denied to officers before?
Harrison Porter for the record. No, in my time with Metro, this has been a new occurrence.
A new occurrence that it
That
now
they have
is-
now started doing it, correct?
Okay, they've now started denying it.
Correct.
Okay, and is that consistent with what's in the negotiated agreements?
Harrison Porter for the record. That they can deny it.
Mm-hmm.
In our agreement, no, they cannot, except for the captain rank.
Okay. Okay.
Chair Miller, if I may step in, I think
Yes,
I might be able to
please.
clarify something for you. So it has happened in the past. It is not a common occurrence. In the past, typically, in my experience, in the 5.5 years I've been with the union, we've had an occasion where a probationary sergeant has, according to the department, had some performance issues, so to speak. Within the policing ranks, if you're on probation, in order for you to come off probation, you have to earn your way off probation. So we have had occasions where the department has stepped in, withheld a step increase coming off of probation, where our association has not got in the way. We are willing to acquiesce that a merit, earning your way off of probation, is certainly the right way to do it. Currently, our contract states that captains' raises are merit-based, which is what the department wanted during last contract negotiations. Sergeants and lieutenants' step increases are not merit-based. Currently in civil service rule states that a pay increase can be withheld for performance or conduct. It is our belief that civil service calling that merit increase is probationary, and we offer one explanation why. Once a supervisor, regardless of rank, reached the top end scale, there are no more step increases to be had, which at the sergeant ranks takes 3 years to top out. At the lieutenant rank, it takes 2 years, and captains, depending on where you get started, 2.5 to 3. I'm not going to belabor that point. But if you're a next to last topped out sergeant and you have what is be deemed a performance issue, was there is no explanation for what is performance. The sergeant's first line supervisor can claim for whatever reason that they are having performance-based issues. There's not a metric that states what a performance-based issue is. There's also not an appeals process to say no, that he is meeting his performance. Under current rule, without this law and this protection, that step 9 sergeant who's not on probation could have his pay withheld for what appears to be an indefinite amount of time until somebody above him claims that his performance is up to par. Where the topped out supervisor, there is no step to withhold. So we're going to treat that topped out employee different than a non-probationary employee working their way up through the steps. And that, in a nutshell, is one of the biggest reasons why we've requested and brought this bill forward. Additionally, as far as holding accountability, there's been a couple questions, and we appreciate those questions. If a supervisor is not performing, and that is the reason why somebody feels their pay needs to be withheld, they are placed on a performance plan. There are metrics based within that performance plan. If that supervisor is not meeting the metrics, then eventually that's going to go to a statement of complaint through the internal affairs process and could potentially end with a demotion if that supervisor is being found not to perform to standard. So to say that this is an accountability tool is categorically incorrect. The accountability tool would be the final finding through the due process that the supervisor is not or cannot do their job, which would then should result in some type of discipline, which could result in a suspension, which is a loss of pay. And ultimately, if they've shown that they cannot do the job, a demotion, which would be a compounding loss of pay because they would go back to the police officer rank. I hope that cleans some of that up.
Thank you for that. Our next question is from Assemblymember Gray.
Thank you. I'm going to try and recap this to make sure I've got it correct. So say you're a sergeant, step 3, coming up on step 4. I don't even know if that exists, but just humor me. You go under investigation. They now, and I'll use your word, suspend or whatever. I think it's more of a forfeiture because they lose that because they never get it back. There's no back pay as long as they're, even if they're cleared, they don't get that back pay. Okay, if they're found culpable and they're demoted, and let's say that they actually got their 4 under the old program, so they're step 4. Now, would they maintain that step since it's time-based? If they go back to an officer, would they still be an officer step, steps 5 or step 4, depending upon where they were before, or does that step follow them even if they're reduced in rank?
Harrison Porter for the record. So just to clarify, you're asking if they're at a certain step as a sergeant and they get demoted, what step they go back to? They would. Troyce, you want to touch on that one for me?
Yes. Chair Miller, Troyce Crimmy for the record. May I go direct?
Please. Thank you.
Okay. Assemblyman, just to answer that question in the most clear, succinct manner, when a sergeant is demoted back to officer, the step that they would fall in would be based on their time in service on the agency of whatever step that would bring them back. into. At the very least, it would result in a 26.25% reduction in pay, regardless of what step they land on. That would be the minimum. But that step would be determined based on how many years of service they have on the agency.
Thank you. I think you just made my point. So that step would follow them that time. Nothing can take that time away. They still get that. So it would be the correlation in the demotion would be the amount of years they have with the department, the step. But if if they don't get that step while they're under investigation, they lose that step increase as well.
They would never gain the back pay at the sergeant rank of that step increase that they were contractually due, and then they would go back, lose the pay that comes with the rank on top of that. Yes, that is correct.
Right. One more follow-on, Chair, real quick, please. Continue. Thank you. So and this is the point I want to clarify real quick. So if they're under investigation by IA and that step is withheld during that time, they are already being penalized just for being under investigation because they will never get that money back for the period that they're under investigation, correct?
It's hard to say never because the department at that point, based on the way the law is written right now, could return it if they want to. They're not compelled to return it.
Okay, thank you. Our next question is from Assemblymember Nadeem.
Thank you, Madam Chair. Thank you for the presentation. My question is almost on the same line. If the officer is under investigation and after the investigation, the officer is found not guilty, so the pay that's been withheld within that period, is that officer will get that pay because he is not found guilty, or even he will not get reimbursed for that one?
Harrison Porter for the record. Troyce, do you want to touch on that one?
Hello, Troyce Crummy for the record. That's going to be ultimately, because of the way the law is written, is up to the agency. In the example that Vice Chairman Porter provided during his presentation, what we were explained was, should that member not be found sustained, that we would offer him that back pay that was individualistic. But that was completely up to the agency. It's my understanding the example provided by Vice Chairman Porter that the Police Protective Association offered to us, I do not believe that officer's back pay for the withholding of the step was given. Unfortunately, the way the law is written currently right now, it's completely up to the agency whether they want to provide that back pay from that step increase should the officer or supervisor not be sustained.
Assemblymember Yurick.
Thank you, Chair. I appreciate the presentation. Here's as I've weighed this. By the way, I appreciate you coming in and talking a little bit about this bill beforehand. And I'm really trying to kind of weigh this out because obviously I think the big distinction here is whether or not we're dealing with a step increase that under the law comes as a matter of right and would occur regardless if you were disciplined or not disciplined, and as to whether or not this sort of step increase would be considered a merit increase. And it sounds like through your contract, or at least through this letter of understanding, that you, for the rank of captain, have deemed it a merit increase, and for those sergeant and lieutenants that you are in your association, those are like step increases that should occur as a matter of right. So ultimately my question is, if we put this into the statute as proposed here under this bill, would that eliminate that distinction? And would it require not just your agency, but all agencies to treat this as a step increase, as opposed to allowing agencies the freedom to kind of figure out, as a matter of negotiations, how they wanted to treat these?
Harrison Porter for the record. I'm going to let Troyce talk about that one since he's been through the contract process more times than I have.
Thank you for that question, Assemblyman Yurick, Troy Crumey, for the record. You are correct. If this law goes through, it would consider all pay increases to be step increases. It would eliminate that distinction in our contract for the captains, and additionally would treat peace officers around the state as contractually obligated pay raises for the step increases.
Okay, thank you for that. Not seeing any additional questions right now, I will open it up for testimony. We'll begin here in Carson City for those testifying in support of Senate Bill 298. Not seeing anyone. Is there anyone in Las Vegas that would like to testify? Okay, also not seeing anyone. Broadcasting, will you open the lines?
If you would like to testify in support of Senate Bill 298, please press star 9 now to take your place in the queue. Again, if you would like to testify in support of Senate Bill 298, please press star 9 now.
Good morning, Chair Miller, members of the committee. My name is John Abel. I represent the LVPPA, which are the LVMPD officers below the rank of sergeant. I just want to echo some of the things that Troy and Harrison have spoken about. So I've had a lot of times we don't know if the step increase is being withheld because payroll does not notify us, so an officer has to notify us. So the only way that we're going to know is if they notify us. Now, I've had officers have had their step increase withheld because their captain believed they didn't write enough citations. Their captain believed they did not make enough arrests over a period of time. And they're placed on a performance plan. And that's when the officer starts to call us and say, hey, I didn't get my step increase. So we have to fight that. And then the argument that I always tell the captains when I speak to them is you shouldn't be taking or withholding their step increase. You should see where the performance plan goes. And then if they aren't performing, then open a statement of complaint and let it go through internal affairs. I've been able to convince some to do that. Some I haven't been able to. And let's be real here. The captains are not going to open up a statement of complaint because an officer is not writing enough citations. And I've told them that. I said, this is never going to go anywhere. So you should give them their step increase. And Metro has just started doing this within the past couple of years. And also, it's not fair across the board. So an officer steps out after 10 years. So myself, I've been on LVMPD for 18 and a half years. I stopped getting step increases at my 10-year mark. So if I were to get in trouble, which would never happen, but if I were to get in trouble, they wouldn't be able to withhold any steps from me because I don't have any steps that are forthcoming. The only thing that I have is longevity. So that being said, we tried to negotiate this with Metro. They're unwilling to do so, I believe. We have a contractually negotiated.
Mr. Abel, you are over time.
Yes, ma'am.
I'm not saying you're getting in trouble, but
okay.
You are over time.
Okay, sorry. Well, for all those reasons, we support the bill. Thank you so much.
Thank you. Okay, and next caller.
Chair, there are no other callers wishing to testify in support at this time.
Okay, thank you. Then I will open it up for opposition testimony, beginning here in Carson City.
Good morning, Chair Miller, the Assembly Committee on Judiciary. My name is Chris Reese, R-I-E-S, and I represent the Las Vegas Metropolitan Police Department. First, I'd like to thank Senator Daly and Lieutenant Porter and Sergeant Crumey for protecting officers and supervisors from arbitrarily and unfairly being denied a step or merit increase in pay. However, that is not what's occurring. In fact, there are very few instances where an increase in pay has been denied because our officers and supervisors earn their merits through their performance, are hardworking, dedicated, and in essence, do the right thing. This bill stems from a single case, which I will quickly summarize for time's sake. A supervisor was demoted for neglect of duty and withheld a merit increase. It should be noted that the arbitrator ruled on the department that the department was justified in both the demotion and withholding of the pay increase. Pay is a mandatory subject of collective bargaining. This bill circumvents that process and mandates that a merit increase be deemed a property right. This would mean that officers or supervisors who are relieved of duty or on modified duty for serious misconduct would continue to receive their increases in pay, notwithstanding the seriousness of that wrongdoing. The unions and the department should be able to negotiate when and if that increase should occur, and this bill undermines that. Further, if the presenters believe that the increases have already been negotiated, then there is no need for this law. Typically, an employee has done a terminable offense, not something minor in nature. To get their increase in pay withheld, in the past, we have eventually terminated that employee. Further, if this bill were to pass, depending on the classification, an employee who commits a crime could still receive their base pay and then would be mandated to continue to receive their increases in pay. It just doesn't seem right or fair. In conclusion, when a pay increase is not earned, it should not be given. For these reasons, we oppose Senate Bill 298. Thank you.
Thank you. Is there anyone else here in Carson City? I don't see anyone in Las Vegas. Broadcasting, will you please open the lines?
If you would like to testify in opposition to Senate Bill 298, please press star 9 now to take your place in the queue. Again, if you would like to testify in opposition to Senate Bill 298, please press star 9 now.
Anne Marie Grant, ANNEMARIE sister of Thomas Purdy, murdered by Reno Police and Washoe County Sheriff's Office, calling in strong opposition to Senate Bill 298 and the continued existence of NRS 289. SB 298 proposes to revise provisions relating to peace officers, including changes to the definition of punitive action. SB 298 claims to clarify and streamline disciplinary procedures for peace officers, but in reality, it further weakens already insufficient accountability mechanisms. It expands protections under NRS 289, which already shield officers from meaningful oversight when they violate people's rights. NRS 289, known as the Peace Officer Bill of Rights, provides extensive safeguards already for law enforcement officers during investigations and disciplinary actions. These provisions, designed to protect officers, can impede transparency and hinder the pursuit of justice in cases of misconduct. By maintaining and potentially expanding these protections through SB 298, we risk creating an environment where officers are less accountable to the public they serve. This not only undermines public trust, but it also compromises the integrity of our justice system. I urge the legislature to reject SB 298 and to evaluate the broader implications of NRS Chapter 289. SB 298 is a step in the wrong direction, and NRS 289 has always been a barrier to transparency and justice. It was never meant to serve the public. It was written to protect the institution of policing from scrutiny. Please do not support this bill. Thank you.
Thank you. Next caller.
Chair, there are no other callers choosing to testify in opposition at this time.
Thank you. Then I'll go ahead and open it up for neutral support. Anyone here in Carson City?
Morning, Chair Miller, members of the August Committee on Judiciary. Appreciate the opportunity to be here. We're neutral on this bill.
I'm sorry. Who's on neutral? Okay.
Sorry.
Yes, your name and please spell it.
So excited to be here, Chair.
I know you would not hear that often, so.
Warren Hardy, representing the city of Boulder City today. WARRENHARDY. My apologies. We're here under neutral. This is a bill that is germane to a subject that's become of great concern to not just Boulder City, but I believe other cities, and this is a bill that's germane to correct it. We're not asking for it to be corrected. We have met with the proponents of the bill and tried to craft an amendment that might work for this session. We were unable to do so, but I did want to make the committee aware of the concern. Earlier in this year, there was a Supreme Court ruling that basically ruled under the Police Officers Bill of Rights that it was required across the board that a police officer can only be investigated by a ranking police officer. We have never interpreted that to mean HR, sexual harassment, other things related to the job. We have no quarrel or problem with the provision applying to matters related to police conduct or police activity. However, on HR complaints, it's always been our practice to hire outside counsel. These are very complex issues that require expertise, just as law enforcement violations are very complex issues that require police officers to understand. The court ruling ruled that, in fact, all of these complaints against a police officer had to be conducted by another police officer. This creates a number of problems, as you might imagine, with regard to HR complaints, but it really, really ties our hand and causes a significant problem. We don't know how legally, after this ruling, that we can investigate chiefs of police. There's nobody ranking to a chief of police, leaves that question unanswered. So, Chair, again, not necessarily asking, the sponsors were kind enough to meet with us. We were unable to come to an agreement. This is the last bill germane to this, and we just wanted this committee to understand the dilemma that we're under. Thanks, Chair.
You know, Mr. Hardy, we still have 3 weeks left, so don't threaten us with a good time. Thank you so much. Anyone else here in Carson City? Not seeing anyone in Las Vegas. Broadcasting, please open the lines.
The public lines are open and working. There are no additional callers for neutral at this time.
Okay, thank you. Then I will welcome the bill presenters back up for any final remarks.
Harrison Porter for the record. I just want to say thank you. Thanks for taking the time today, and thank you for the consideration.
Thank you so much. With that, I will go ahead and close the hearing on Senate Bill 298. Last order of business today is public comment, so inviting anyone here in Carson City that would like to make public comment.
Tanya Brown, TONJABROWN, Advocates for the Inmates and the Innocent. Good morning, Chair Miller, members of the committee. Nevada must create a clear, independent mechanism to exonerate the innocent, prevent future wrongful convictions. Right now, there is no reliable path forward for deceased persons who have died while maintaining their innocence. There is there is no meaningful remedy for those failed by the system and who have died in prison wrongfully. That is not justice. Wrongful convictions destroy lives, devastate families, and erode public trust. They happen because of human error, flawed forensics, mistaken identity, and sometimes prosecutorial misconduct. But Nevada's laws do not provide for an adequate remedy when those errors are discovered. And when misconduct is discovered, prosecutors are held accountable by law and not led up to the State Bar of Nevada, who does not hold them accountable for breaking the laws on discovery. Nolan's Law would level the playing field on discovery. We ask that in 2027, laws be created to ensure true criminal justice, reform for the wrongfully convicted, allow the family members of those who loved ones have been wrongfully convicted and passed away. We're looking at, again, with today's bill, AB 473, we had put an amendment, but it was not accepted. I think it would have been perfect for that bill. And to reconsider all of this in the future for 2027, because apparently it's just too late now. I will tell you that there is a movement moving right now down in Southern Nevada and up here on wrongful convictions, and this is going to be a topic of the conversation for the 2026 elections. Thank you.
Thank you so much. Anyone else here in Carson City? Not seeing anyone here or in Las Vegas. Broadcasting, will you open the lines?
If you would like to provide public comment, please press star 9 now to take your place in the queue. Again, if you would like to provide public comment, please press star 9 now. Caller with the last 3 digits, 556, please press star 6 to unmute your phone. You may begin.
Anne Marie Grant, Advocates for the Inmates and the Innocent, ANNEMARIEGRANT. Today, May 9th, marks the 37th anniversary of the 1988 Sparks Payless Shoe Store robbery, a crime for which Nolan Klein was wrongfully convicted of. Nolan died in prison, still maintaining his innocence. Evidence that would have exonerated him was withheld by the Washoe County DA. Nolan is innocent, and evidence proving that was withheld. And today marks nearly 4 decades since this injustice began, and yet accountability remains elusive. The Washoe County DA's Conviction Integrity Committee has proven itself to be little more than window dressing. It lacks transparency, independence, and any meaningful mechanism to correct wrongful convictions. Nevada must do better. We need laws that hold prosecutors accountable when they withhold exculpatory evidence, because when they do, innocent people like Nolan die in prison and the true perpetrators walk free. The families are stigmatized forever. Without enforceable consequences, there is no justice, only unchecked power. As we remember Nolan Klein today, I hope that in the 2020 session you will advance legislation that advocates for the inmates and the innocents are putting forth Nolan's Law, which states once a defendant is arrested and charged with a crime, the law enforcement agency must provide accused defense counsel with a copy of all materiality exculpatory evidence at the same time the prosecution receives it. Then it will be left up to court to decide what is or is not admissible for trial. Any additional materiality exculpatory evidence that is provided to the prosecution must simultaneously be provided to the accused defense counsel. Justice delayed should not be justice denied, not for Nolan and not for anyone. Thank you. Have a good day.
Thank you. Next caller.
Sir, there are no other callers to provide public comment.
Okay, thank you so much. Then I will go ahead and close public comment. And we are finished for today. Thank you, members. I will go ahead and adjourn and see you back. Assemblymember Cole, which time will we be returning on Monday morning? That is correct. I will see you back at 9 a.m. on Monday morning. Have a great weekend.